Good morning, Section Z. We're in Chapter 12 on Takings Law, and we're looking at next the case of Lucas versus South Carolina Coastal Council. Let me pull that up on our screen. It's over on page 657 in the Duke Community textbook. This is a case where Lucas bought two lots on the Isle of Palms in South Carolina. The lots were located about 300 feet from a beach in a residential neighborhood. So they've got a diagram down at the bottom of the page showing here is the Atlantic Ocean, and then here are several lots that have houses on most of them, but notice that lot 11 and lot 13 are vacant, and those are the lots that Lucas purchased. There is a picture down further in the book. So here is at least one of the lots that Lucas purchased. Kind of maybe you can see both of them in this picture. I'm not sure exactly what they're showing us, but you can see the large houses along the beachfront and then vacant lot here, which I presume is one of the ones that Lucas had bought. And he bought them with the idea that he would put a single family residence on each one. He paid $975,000 for the two lots. So almost $500,000 for each of the lots. At the time he purchased the lots, it was permissible to build on them. There was a statute in place called the South Carolina Coastal Zone Management Act, but it didn't apply to these lots at the time of purchase. And so a number of neighbors had built on lots around these two. But after Lucas buys the properties, the Beachfront Management Act of 1988 is passed, and the South Carolina Coastal Council designates an area, including Lucas's lots, in which construction of occupiable improvements is not permitted. And so now suddenly there is a new regulation from the state of South Carolina that says you can't build on the lots that he purchased. So we talked about how in many cases, when you're trying to decide whether a regulation is a taking requiring just compensation, you're going to apply this balancing test that we saw in the Penn Central case and elsewhere, taking into account various factors, including diminution of value, effect on investment-backed expectations, character of the government's action, etc. But then we saw that there are particular cases where the court carves out a per se or a bright line rule. And one of those was the one that we saw in Loretto, that a permanent physical occupation of somebody's property in pursuance of a government regulation by some third party is a taking per se. And then here, the court finds another per se rule that it applies in the law of takings. So over on 658, they say, we have, however, described at least two discrete categories of regulatory action as compensable without case-specific inquiry into the public interest advanced in support of the restraint. The first encompasses a regulation that compel the property owner to suffer a physical invasion of his property, in general, at least with regard to permanent invasions. No matter how minute the intrusion and no matter how weighty the public purpose behind it, we have required compensation, citing Loretto. And then they say the second situation in which we have found categorical treatment appropriate is where the regulation denies all economically beneficial or productive use of land. As we have said on numerous occasions, the Fifth Amendment is violated when land use regulation does not substantially advance legitimate state interest or denies an owner economically viable use of his land. So this is not a principle that sprang into existence to decide this case. It was something that they had said in earlier cases, but here the court decides that that principle applies on the facts before it. And the basis for applying that principle is the state trial court, which had entered a finding that the regulation of the lots owned by Lucas, preventing him from building on them, left the land valueless. Now, the dissenting opinions think that's a pretty implausible finding. would a building prohibition mean that this land has no value at all? I mean, if you think of it in those terms, the answer is probably no. I mean, if we took up a collection in the class, we could probably pull together, $1,000 for buying a lot on the Isle of Palms, even if we couldn't build a house on it. As I think Justice Stevens suggests in dissent, there are still things you can do with it. You can picnic there, you can swim, you can camp in a tent, you can live on the property in a movable trailer, you can sell it to neighbors or others. So the court accepts the state court finding, but the dissenters say that's just not plausible. That's not, kind of doesn't make sense that this land has no value. And so why does the court accept the finding? I guess one possibility is just that they are paying their typical deference to factual findings in lower courts. They think of themselves as concerned principally with issues of law. And so when there has been a fact finder that makes a factual determination, they usually don't question that factual determination, but just kind of take it as a given for purposes of applying legal principles. Or the other possibility that might make sense in light of the opinions here is that they view the uses that are proposed by Justice Stevens to be irrelevant because they're not economically viable uses, right? That you might be able to get somebody to pay $1,000 for the lot, but that you're not going to find anybody willing to pay $500,000 for one of these lots just so that they can camp and have picnics there. Now, one of the issues that we have come across in the cases is this issue of conceptual severance. And so when you're applying an analysis to decide how much value has been lost as a result of a government regulation, the court sometimes views that as a fraction. And the question is, what is the denominator of the fraction? What is the whole against which the diminution in value should be measured? And so Justice Scalia raises that point down here in footnote 7. And he suggests that the court's opinions have not been particularly consistent on this point. That he suggests that that the court's cases don't all apply the same view of the relevant unit of property against which you measure the deprivation of value. And then he offers a proposal. Notice this is dicta. This is not something that he has to decide to resolve this case, because the state trial court's finding was that the lot as a whole had become valueless. But he suggests a way that the court could try to address that in future cases down here at the bottom of footnote 7. He says, the answer to this difficulty may lie in how the owner's reasonable expectations have been shaped by the state's law of property, i.e., whether and to what degree the state's law has accorded legal recognition and protection to the particular interest in land, with respect to which the takings claimant alleges a diminution in or elimination of value, right? And so if you want to decide, do we have to look at all interests in a piece of property, or can we carve out one particular interest and look at the effect of the regulation on that interest, then maybe you look to the state's prior case law, see to what extent the state has treated that separate interest as a legally recognized and protectable interest in land, and then see how that might have shaped the reasonable expectations of people buying property in that state. Now, Justice Stevens thinks that the developers and investors in the real estate market might market specialized estates to take advantage of the court's new rule, and here, Scalia's suggestion about applying it to some subset of rights in the property. He hypothesizes that maybe you could have an investor who would buy the right to build a multifamily home on a specific lot with the expectation that it will be zoned for single family residential use, and that would make his particular property interest valueless. And so that, he's thinking that people might speculate in the real estate market, trying to set themselves up for a takings claim against the government. I wonder how plausible that really is, that investors would behave that way. It seems a very speculative investment, right? You have to imagine that the investor is interested in buying a particular property interest that they expect not to be able to use, in the hope that the state will pass a regulation preventing them from using it, so that they can then bring a takings claim and get the fair market value of that right. I'm a little bit dubious that a lot of investors are going to want to speculate that much. On the other hand, there are people who buy lottery tickets as an investment, so maybe so. But conceptual severance is not an issue in this case, because the state courts found a denial of all value in the property as a whole. So the court has this case law out there suggesting that if that happens, if you have deprived a landowner through your regulation of all economically viable use of the property, then it will be deemed a per se taking. But the court also notes exceptions to that rule, that there can be situations where the state deprives an owner of all economically viable use of their property and yet does not have to provide compensation. And so one of these is over on page 662. Basically, the idea is, that where the state seeks to sustain regulation that deprives land of all economically beneficial use, we think it may resist compensation only if the logically antecedent inquiry into the nature of the owner's estate shows that the prescribed use interests were not part of his title to begin with. In other words, if the regulation prevents the landowner from doing something that the landowner already had no right to do as a matter of state property law, then nothing has been taken from the landowner, that the court is simply, or the state is simply kind of particularizing and verbalizing a restriction that was already in existence on the landowner's property, and therefore they have taken nothing that requires compensation. And so they kind of elaborate on it further down on the page. We believe similar treatment must be accorded confiscatory regulations, i.e. regulations that prohibit all economically beneficial use of land. Any limitation so severe cannot be newly legislated or decreed without compensation, but must inhere in the title itself in the restrictions that background principles of the state's law of property and nuisance already place upon land ownership. A law or decree with such an effect must, in other words, do no more than duplicate the result that could have been achieved in the courts by adjacent landowners or other uniquely affected persons under the state's law of private nuisance, or by the state under its complementary power to abate nuisances that affect the public generally or otherwise. So basically, if the regulation is simply kind of verbalizing and making explicit the rule that you cannot use your property to create a private or a public nuisance, then compensation is not required, even if the effect of the rule is to deprive you of all economically viable use of your land. You never had the right to use your land that way in the first place, and therefore the government has taken nothing from you. What about in this case? Would construction of houses on Lucas's 2 lots in the Isle of Palms constitute a nuisance at common law? The court says it seems very unlikely. There were already houses on that in that area. The neighbors had houses on their lots and hadn't been ordered to tear them down as nuisances. And so, sure enough, when they sent the case back down to the South Carolina Supreme Court, or the South Carolina courts on remand, the South Carolina courts determined there was no common law nuisance under South Carolina law. Apart from regulation of common law nuisances, is there another situation where the state can deprive you of all economically viable use of your property and still not be required to pay compensation? Justice Scalia mentions another possibility in footnote 10 down at the bottom of the page. The principle otherwise that we have in mind here is litigation absolving the state or private parties of liability for the destruction of real and personal property in cases of actual necessity to prevent the spreading of a fire or to forestall other grave threats to the lives and property of others. And he cites the Bowditch versus Boston case that we have seen previously, where they kind of blew up a house so that it would not, so that a fire could not spread to that house, and then from there to other houses. No taking found in that case because the government is trying to deal with an emergency situation, and the court thinks that's another situation where the government would not be required to provide compensation because they're simply exercising an option that was already built into the package of your property rights that you own. Now, note 2 after the case. So the authors are talking about nuisance law, and they point out that nuisance law is very flexible, right? That it's based upon an ad hoc balancing test. And so they wonder if whether Justice Scalia's exceptions follows up the rule. If the way you determine a common law nuisance is by applying multi-factored analysis, do you essentially give the state the ability to say, oh, this is a nuisance, and therefore the regulation does not require compensation? Well, of course, that didn't happen in this case because the South Carolina courts had trouble reaching a conclusion that building on these lots would be a nuisance. Justice Kennedy emphasizes that to find that a regulation addresses a nuisance, it has to be based on objectively reasonable expectations generated by the state's pre-existing law. So you can't kind of take your nuisance law in a whole new direction and say, oh, see, this is a nuisance as we now understand that concept. Note 3 on that page, the authors focus on Justice Blackmun's dissenting opinion, Lucas, where he says, today the court launches a missile to kill a mouse. So what's he mean? Is this case a big deal? Did the court need to apply a per se rule, or could it have reached the same result just by applying something like the Penn Central balancing test? Will the court's new rule create a lot of collateral problems, as Justice Blackmun fears? Or are situations where you deprive property of all economically viable use so rare that this case will have very little effect? I think Blackmun is saying that the missile here is adopting a per se rule, that in takings law that is kind of strong medicine, and that it wasn't justified to resolve this particular case, this mouse. You could have resolved it without kind of creating this missile that then sits around waiting to be used later on. Now, notice the note on page 670 about what happens after this case. That after the case, the state of South Carolina finds itself owning this property, and that it does not continue its prohibition on building. In fact, after paying $1.5 million to Lucas for fair market value of the lots, the Coastal Council then sold them to a developer, and eventually houses were built on those lots, which is kind of an interesting point. It makes you think about this whole purpose of takings jurisprudence, that you're trying to prevent the state from imposing upon private individuals costs that really ought to be borne by the public as a whole. And so in this case, the Coastal Commission was quite happy to impose this regulation where Lucas was the one who was going to lose $1 million as a result. But then when it was their own property and they were the ones who stood to lose $1.5 million, then suddenly they decided that the regulation was not important enough to keep it in place, and they sold the property to a developer. That is a good point to stop at,